Are you concerned as a criminal defense attorney about the level of information that has already come out publicly from the FBI?
Good afternoon, Del. Thanks so much for having me. I think everybody has a fair level of concern when it comes to high-profile cases like this, and whether or not the information that's released will ultimately impact a jury if this ever got to a jury phase. Ensuring that the client or the person accused of the crime is given the fair trial that they have the right to have. However, the court and counsel are typically familiar with processes that can be put in place and mechanisms that can be used to limit the effects that this type of commentary has on the outcome of a case, whether that's gag orders or curative instructions, limiting access to the media. There are things that can be done to limit the impact, where we focus on the evidence versus the commentary.
Ms. Nieves, what is the difference between press accounts, for instance, the Washington Post, saying that they have seen text that would seem to indicate that Robinson has actually confessed, and the words from the FBI director?
I think one thing that we can rely on is that in the information that the county attorney read from, he indicated some of the texts that were used in making the charging decision, and they did reflect certain admissions. They did reflect communications with the roommate indicating, yes, I left a note behind and I had an opportunity to Kirk, and when directly asked about it, are you the person who did this? He said, I am. So I think that there is a level of corroboration to whether or not these admissions exist, and the commentary from his parents about comments that he made to them implying his involvement in murder.
Ms. Nieves, you know, as a criminal defense attorney, that all sides work together on these cases. The county sheriff, the local police, the university police, they bend over backwards to make sure that they give each other credit. Is this a situation where the FBI director is simply bigfooting?
I do believe that there may have been a lot more information released at the outset while an investigation is still taking place. I do think that in any case where a prosecutor is making a decision about how to charge a case, they'd rather keep cards close to their chest, right? So that they have the ability to pursue an investigation and direct law enforcement in a way that can help them secure a conviction, and limit kind of the taint that may occur if too much is released too soon. I think that it's better to be a bit more measured and judicious with what's put out there at first, to ensure a fair trial to begin with, but also to ensure that an investigation can proceed without it being obstructed or tainted in any way.